Good afternoon, everyone, and students, researchers, and colleagues. It gives me great pleasure to welcome all of you and also all the panelists for this panel discussion session. The theme of today's panel discussion is emerging power in international relations. As being a student of geopolitics and international relations, we know that power has always been central to all the discussion of international politics. Power, along with identity, then other factors, have always been central to the discussion of international relations. But during last 20 to 30 years, the whole dynamics of power has changed a lot. It may be attributed to a number of reasons, including globalization and then democratization. Then also we have a lot of other factors in that. So in this regard, this would be a kind of appropriate time to discuss that how power is changing at the global and regional levels and how it has implications for different new emerging actors are coming up and other things. So after saying these all things, I would like to welcome our first panelist, Dr. Boguslav, who graduated with honors from University of Warsaw, Faculty of Law, Administration, Institute of Civil Law in 2011. As his research interests basically are related to different legal and institutional dimensions, so I think he would be going to speak on related issue, that is how this emerging powers has relationship with public international law perspectives. So welcome, Dr. Boguslav.
Thank you very much for the invitation. It is a great honor again to be here. I'm going to talk about emerging powers from public international law perspective, and it is, frankly speaking, it is difficult to talk about emerging powers from this perspective because in the light of the principles and of the provisions of international law, there is no such a category of states. So I'm going to talk and to explain that it is difficult to distinguish such a category of state and to explain in legal terms this category. And starting point should be one of the most important principle of international law, which is principle of sovereign equality of states. And as we regard the principle of sovereign equality of states, we should know that the states are formally equal, yes, and they cannot be differentiated from each other. So they have formally equal position in the light of international law provisions. It means that no one state formally can make another state to do anything. No one state can have jurisdiction over the other state. And it is a very important thing to understand why the lawyers dealing with public international law have problems with taking into consideration, in the practical terms, the category of emerging powers. Of course, to the principle of sovereign equality, there are some exceptions in the public international law. I've chosen two exceptions visible on the presentation. The first is mentioned, was introduced in the Article 23rd of the Charter of the United Nations. And there was established that the most important states, I think, are permanent members of the Security Council. And this is the exception to the principle of sovereign equality, because we have a group of states, a category of states, which have special position, not only by force of fact, not only by force of their economy, military position, but by force of law, by force of provisions of one of the most important sources of international law, which is the Charter of the United Nations. The second exception to the principle of sovereign equality arises from a Vienna Convention on treaty law. The exception arises from Article 75, which distinguishes a category of aggressor state. Aggressor state is a state which can be imposed with obligations by the other states without its consent. So it is very important exception. And we see through these examples that in order to introduce an exception to the principle of sovereign equality of states, we have to have explicit legal basis. We cannot make any exceptions to the general principles of international law, public international law, without explicit legal basis. And as I mentioned, the legal basis justifying emerging powers as a category of states is missing. We have no legal basis to distinguish such a category of states in public international law, and I'm talking about treaty law as well as customary international law. There is no such legal basis, and it is the state we have. And now we have to face the question if the international community of states as a whole is ready to introduce the exception, to introduce a new category of states which can be called emerging powers. If we say no, the discussion concerning emerging powers from international law perspective is meaningless in practical terms. It can be a theoretical game. But if we say yes, it is necessary, it is useful to distinguish in the light of international law a new category of states called emerging powers, we have to ask two more questions. We have to answer two more questions. The first is, what should be the legal criteria of classification of states as emerging powers? And the second question, very important, very close connected with the first, is what should be the legal implications of recognition of a particular state as emerging powers? And facing the first question, it should be pointed out that the criteria may be different. The criteria may be of economic, social, political, military character. We should ask if a criterion should be position of state towards human rights. It is kind of provocative question, but I think we should address this problem. And the criteria of classification of the states as emerging powers should correspond to the consequences which we want to link with classification of a particular state as emerging powers. And I selected some possible consequences which can be linked with classifying a state as emerging powers. We should ask if classifying a state as emerging power should be connected with granting special rights to them, especially of regional character. We should ask whether classifying a state as emerging power should be connected with imposing on the state special obligations, especially in the terms of responsibility for safety, for peace in their region. We should ask whether the states classified as emerging powers should have any special rights in the United Nations. Maybe they should be semi-permanent member of the Security Council, but introduction a new category of members of the Security Council requires change of the United Nations Charter. So I think it is very difficult to do. And the last question concerning the emerging powers in legal terms relates to representative of diplomats of emerging powers. Should the diplomats of emerging powers have any special competences regarding the representing the whole region where the country classified as emerging power is? And I don't dare to answer any of the questions. It is very difficult. I think that nowadays it is impossible to distinguish in legal terms emerging powers. I think that the community, the international community of states, is not ready to change international law in order to create a possibility to distinguish emerging powers as a separate category of state. The best way to introduce emerging powers as a new category of state should be change of the Charter of United Nations. But there were so many attempts to change the Charter. All of them collapsed. All of them were ineffective, that it is hardly to believe that change in this scope of the Charter can be successful. So nowadays, from the legal point of view, the notion of emerging powers has no practical meaning. It is kind of descriptive notion, but classifying a state as emerging powers has no legal implications. Thank you very much.
Thank you, Dr. Boguslav, for raising very interesting points that what are the challenges for emerging powers, because I think some of the points what you raised, that there is no legal framework which can address this problem, and the other existing powers, they are not ready to make any kind of reforms in these legal and institutional frameworks. So basically, the point whatever you have raised is related to in the context of nation state. But as we know that we are also living in an era of complex interdependence, and where other important non-state actors are also playing role. And economic factors are becoming very important at global level. Just yesterday I was also hearing that geoeconomics, and then from geopolitics to geoeconomics and political economy, these things are becoming very important nowadays. So in this context, I think our next panelist will throw more light, because he has been doing her research and studies in this area of geoeconomics and geopolitics. So I would like to welcome Dr. Karina, who is a junior assistant professor at Institute of International Relations, University of Warsaw. And although she has started her career as a political scientist and expert of international relations, but when we see the last recent things, she has been mainly focusing on economic dimensions. And when we see global trade volume, then also economics is becoming one of the major factors determining new global order in the wake of rise of China and Brazil and India's economic rise. So in this context, it would be very good to hear Dr. Karina, and she will be speaking on emerging economic powers, selected definitions and criteria for classification. Welcome.
Thank you. Thank you very much for the ability of being here again. And as was already